It's time again to have your legal questions answered, and attorney Gilbert Adams is joining us today. Thank you so much for joining us.
Thanks for having me.
We've got some pretty big questions, so we'll get right to it. My husband has one medical bill in collections. When we called to inquire, they told us the bill had been entered 5 times on 3 credit reports, and therefore we need to pay the $500 bill 5 times to eliminate it. Is this true?
No.
That sounds kind of crazy.
That's definitely not true. It's not uncommon for debt collection agencies to do this kind of thing. The first thing you need to know is you need to verify that the debt is a legitimate one. Ask whoever's calling or writing for account numbers, receipts, this type of thing. If it is your debt, you need to be aware of there's something called the Fair Debt Collections Practices Act, which restricts their ability to contact you both frequently and in writing, etc. So you need to be aware of that. There's penalties if they violate that. If you do decide to pay the debt, you verified it is your debt, and you've decided to compromise it, make sure you get something from them in writing so that if they fail to notify the credit agency, that you can send it in that, hey, I've paid this debt, please take it off my credit report.
Right. Well, that's great. So you can have it taken off yourself once you've paid it.
You sure can, but oftentimes they're going to ask for some writing about it, and if you don't have a writing, you're not going to be successful.
Okay, fair enough. Question number 2, how can my husband legally adopt my son by a former marriage?
Well, it is possible to adopt a stepchild. It's a 2-step process. It's not a do-it-yourself legal project for sure.
Right.
The first thing that has to occur is a termination of the parental rights of the stepchild, and that can be done in a couple of ways. The parent could agree to it, or the court can do it based on a number of factors. And then the second step is the adoption. So the first part is much harder, and again, not a do-it-yourself project.
Right. Okay. And last, my wills names my ex-husband as primary beneficiary and representative of my estate. Is a will null and void when you get divorced in Texas? Do I need a new one? 2
questions there. Is your will null and void? And the answer is no, it's not. The legislature has made a provision for this, and they've said basically to treat the ex-spouse as having predeceased the person in the will. So the will is valid, but it'll take care of not awarding property to the ex-spouse.
Sure.
But the will it continues to be valid, so you may have left property to some of his family or her family or whatever. So yes, you have a change in marital status, you probably do need to get a new will.
Okay. And, well, of course, if you have a question of your own that you'd like to submit to air on our program, just email us at asktheattorney@fox4beaumont.com, or you can call Gilbert Adams yourself, 835-3000, with your legal questions.